Good afternoon. Thank you all for coming. Everyone in the room physically knows who I am, but those online may not. My name's Leo Saunders. I'm a barrister at Greenway Chambers. Worked for a long time at a trade union before coming to the bar. To my right, not visible on screen, is Matthew Minnuci. He will introduce himself in due course. We thought about introducing one another, but decided the risk of it descending into like low rent workplace bullying was too high, so gave it a pass. Welcome to the annual Greenway, the hottest topic in employment law talk. The most exciting part of the talk is always discovering what said topic is. It is money. It is, or more formally, setting wages for employees and ensuring they get paid as they are. Sure, this may be the same talk as last year and the year before that, but you never know. What we're actually going to talk about is three aspects of the range of developments in this area that have happened recently. First, same job, same pay orders. Section 323, which deals with the obligation to pay an employee in full, the related question of permitted deductions, and wage theft legislation. I'm doing the first two at speed, and then Matthew is doing the more detailed talk about the more serious criminal offence that now exists. Same job, same pay orders come in a particular political context. They're a recent addition to the Fair Work Act. There are a range of matters that led to their introduction, but one of the primary focuses was the growth over the last, I want to say, decade of what's described as in-house labour hire. Two key that prevails across a range of different sectors. It's a situation where an employing entity has perhaps a highly unionised workforce with a history of bargaining high conditions set for the particular work with an enforceable industrial instrument there, sets up and this is completely legal, completely legitimate in that sense, sets up a fully owned subsidiary that hires new employees under the award or a separately negotiated instrument, has the effect of reducing pay and conditions. It's been going on for a long time. A few crunch moments in the last, say, 5 years. One was the impact of the Rosato litigation, by which I mean Rosato and WorkPac, the long-standing argument about the definition of casual employment. Mr. Rosato was employed by WorkPac to work at, I think BHP, but don't quote me, a coal mine, as a mine worker in a situation where the established directly employed workforce were permanent employees, highly unionised, good conditions. The business model rather depended on those labour hire employees by WorkPac and others being correctly classified as casuals because it changes the nature of their engagement. There was some concern, certainly after the first instance and full federal court decision, that this model would not persist. BHP responded to that for a range of reasons I don't purport to directly know, by setting up their own in-house company known as OS Maintenance, OS Production, to directly employ people on a permanent basis to reduce this risk of casual employees, but again avoiding or stepping around the existing conditions for employers. Ultimately, the CFME was not successful in Rosato, and the High Court result speaks for itself, so perhaps this whole thing could have been avoided, but there are a range of different reasons that OS Maintenance, which now employs, and Production, which now employs people doing exactly the same job next to others in a coal mine earning less, persists. It's much older than that. The in-house labour hire model has had a significant foothold in aviation for over a decade, certainly decades. You see it in Qantas with baggage handlers, flight attendants, various other unionised groups with organised activity, wholly owned subsidiaries hiring people on different rates. It undermines bargaining for both groups. The new employees have less leverage, less control in the workplace. They are able to achieve less practically, and the older employees become, the conditions become preserved. It was perceived by the current Labor government as something undesirable, and so we get same job, same pay orders, which very catchy name. It came in through closing loopholes too. Incidentally, this graphic took me ages.
That I believe.
I learnt things doing it. It was a really productive afternoon for me. Closing Loopholes 2 did a lot. One of the things it did was introduce what was being described as same job, same pay. It's a catchy name. It does what it says on the box. It's a very catchy second reading speech from the minister. You had, at the time, Tony Burke, you had in the gallery a number of CFMU members, and the man is pointing, Brodie, you have worked for this particular coal mine for years, you're employed by OS Maintenance, this bill is for you, Brodie. Very empowering, very disappointing for the flight attendants who are slightly more affected due to not earning $200,000 a year. Excellent speech, and then a huge amount of post-second reading speech negotiation, which has affected both the readability of the legislation, which wasn't great to begin with, but also the substance of the provision. We get to the less catchy actual name of the thing, the Regulated Labour Hire Arrangement Order, which we find in Part 2 of Division 7A. It concerns, to get there, you need four things to exist. You need an employer, someone who is employing persons, employees, that's them. You need the regulated host. This is the entity for whom the work is actually being performed. And a regulated instrument, some kind of Fair Work instrument that applies to employees of the regulated host at this point. So it's a situation where it replicates the idea of same job, same pay. You're going, is there something that would apply to these people employed by the employer if they were in fact employed by the regulated host and performing the same work? So 4 critical components, which becomes important when one considers the exceptions. You have those 4 things. You've identified a labour hire company who employs people who work for a particular host that has an enterprise agreement that applies to this work. You can apply for this kind of order. Do you necessarily get it? No. There are a number of exceptions, probably isn't quite right, but ways around it. The first is it does not apply to small businesses, small business labour hire employers, I should say. Do you get many of those? Probably not in mining, probably not in aviation. It can happen with the specialised work. It is discretionary. If the Commission is persuaded that it is not fair and reasonable in all the circumstances, notwithstanding same work covered by an instrument, same workplace, the order does not necessarily need to be made. And then the really critical exception, and what's been the subject of most of the contested litigation, all one case of it, is subsection 1A. This was introduced following the second reading speech, and it is directed at concerns to do with what could be described as traditional labour hire, specialist workers or genuine people coming in that the business doesn't supply. You get this language, an absolute exclusion. The Commission must be positively satisfied that the performance of work is not or will not be for the provision of a service rather than the supply of labour. And what we see from that is language that's been, it's not adopting it, but it's been drawn from the pre-Rosato understanding of the common law approach to casual employment, the dichotomy between engagement for services or engagement to perform a service. The fact that those concepts are being drawn on, again, not adopted in a statutory sense, but informing the discretion, are shown by what's required by subsection 7A, which I haven't extracted because it's extremely long, fundamentally. But it directs the Commission's attention to various matters in assessing this, what at least I say is a broad evaluative exercise weighing up various considerations. Other people say if there's one indicia that points to service, it is a service provision. We'll find out shortly for reasons I'll return to. You're looking at the questions of the employer rather than the host's involvement in the work, how much they're directing and controlling it, which is distinct to the day-to-day supervision on site of the workers, the extent to which the employees use plant systems equipment of the host employer, how much they're dependent on the site itself. This one everyone's a bit confused about, the extent to which, including me, frankly, the extent to which both the employer is governed by industry or other professional standards. I think it's linked to the final qualification, the degree to which the work is specialist or expert. Very little guidance yet on what any of this means, but what it is clearly drawn from is the classic Hollis and Varbu list of indicia pre-Rosato test. You're looking at the degree of control, the nature of the work, the nature of engagement, the genuineness of the person's position in the organisation. What happens if an order is made? The obligations include the employer, so the labour hire company, take Rosato, WorkPac is required to pay what's described under the Act as the protected rate of pay. Does not matter if there is a existing enterprise agreement, except unless that agreement provides for a higher rate. So it's a lift-up clause. why anyone would bother seeking one of these orders for a company in which there was an enterprise agreement that provide for a higher rate is unclear, although conceptually you could have varying scales within a classification. There is an obligation on the regulated host, which is to provide information that, in short, that allows they're not called the regulated employer, but the employer who is the subject of the regulation order to, in fact, comply with this obligation. And there's a subset to that if you have failed to pay someone the correct rate because, frankly, the regulated host hasn't told you what it is, that is a way to avoid liability. Division 4 of the part is really interesting and has as yet had no attention and won't for some time. It's the anti-avoidance provisions. It is not a civil liability provision, it is an offence to engage in behaviour conduct, I should say, that either prevents same job, same pay order, which we all really want to call it, but sure, we'll go with the worst acronym known to the Fair Work Act, the Regulated Labour Hire Arrangement Order, to avoid one being made or to step aside, to avoid one being made at all or to avoid its operation. A clear example of this is offshoring, which is possible in aviation and classically occurs in aviation to avoid these things. There is a real argument that if a major airliner, for example, faced with one of these, as they all are presently, some in fact have been made, in fact just stepped aside and said, in fact, all our international flight attendants or even domestic are going to be employed in New Zealand or Singapore, whatever, that it would offend these sections. That may or may not happen. If it does, it'll be extremely interesting because the definition of the conduct that is caught by the anti-avoidance provisions is extraordinarily broad. The term that's used is scheme. Scheme is then defined within the part to be basically anything, possibly even thinking of an idea. So it's something to watch, but quite happily hasn't happened yet. There is a further qualification. So you've already got the orders are discretionary, the orders consider whether it's fair and reasonable. You've already got these various protections for service provisions. It is possible for an employer who is subject to or likely to be subject to a order to apply for an alternative protected rate of pay. The protected rate of pay, remembering the also badly described slide, is the rate of pay that they're obliged, regardless of their industrial instrument, to pay. The order would be directed at how it is to be worked out, and it's by reference to not just what anyone thinks the rate should be, it's directed at alternative industrial instruments that apply either to related body corporates that perform the same work, which sounds confusing, but it is actually directly relevant, or ones that apply in-house. The Commission has, again, it's discretionary. It's a broad evaluative assessment. Would it be unreasonable for the designated rate of pay to apply, the rate that the host employer instrument requires to apply, in all the circumstances, particularly considering whether it is insufficient? Seems practically unlikely, but again might arise in situations where there's a complicated classification scale, or much more likely, and what is actually happening in the application, there's an argument that it's excessive, that it's too much for whatever business reason. Again, this graphic took me ages. I did it entirely in PowerPoint, and it's a new competency point for me. Current events. This is what's actually going on in this section. We've had one seriously considered decision. It's the batch fire decision earlier this year. It's a black coal mining decision. Batch fire is what we're all calling it. The actual name of the case is application by the Mining and Energy Union, but that's really not going to narrow it down for these, so we are starting to go by the employers. Largely uncontested. Two things that come out of batch fire that are of importance are the full bench's determination that none of this turns on the precise nature of the formal arrangement between the employer and the regulated host. You can dress that up however you like, and they are dressed up in complicated ways, particularly with in-house labour hire. The focus is on the work, the instrument. Secondly, the question of fairness, whether it's fair in all the circumstances to make it that discretionary consideration we talked about earlier. What the bench has determined is that only matters if actual arguments are advanced. The Commission is not going to go on an adventure to generally assess these things. You've got to front up and say there's some reason that this is not happening. What's actually happening? This is just light gossip. OS maintenance and production, we talked about earlier, the sort of touchstone in-house BHP cases. Those have been filed. They were heard. The evidence was heard over a tremendous 9 days in the back end of January in Brisbane, in the middle of Brisbane summer. That was great. Another 3 days for submissions. I think it's done. We're expecting a decision. The heavy contest there is about whether they are a service provider. It's going to be very embarrassing if we lose, given that one of those employees was, not only the company was named in the second reading speech, but one of the affected employees was as well. But I anticipate we'll see a decision in the next month or two, given what happened. Full bench of the commission too. Qantas and Jetstar, and so you see here a photograph of 3 Jetstar flight attendants. They could conceivably be on one plane and conceivably be employed by 3 different employing entities, all of which are wholly controlled by the Qantas Group. Jetstar is the current subject of a application for a same job, same pay order. You will all be shocked to hear, given what I just said. That is likely to be contested and likely to turn on the alternative protected rate of pay, because there is one of the subsidiary companies has a separate enterprise agreement to the main Jetstar agreement. The Qantas ones are largely resolved. Same situation. You walk onto a plane and there is no certainty that these people wearing the same uniforms are employed by the same people. You can largely guess by age, because these companies have stopped employing people in the older entities with the new conditions, but that's not universal. That's the end of Same Job, Same Pay. It's a brief overview. The other topic that I wanted to talk about, which is arguably completely unrelated, is Section 323 of the Fair Work Act, which deals with the obligations of employers to pay an employee in full, in money, and at least monthly, none of which, I don't know, maybe my perspective skews, but none of which has ever struck me as particularly outrageous. It's a section that's the subject of current controversy in the federal court. There are now 2 very recent, close to directly competing provisions, but it's always been a bit ambiguous as to how it works. You hear a lot about unlawful deductions, and it's not quite the right structure here. The primary obligation is to pay in these 3 ways: in full, in money, and at least monthly. And those are clearly 3 different things. In full speaks for itself. In money, I'll come to in a moment, and monthly is its own thing about time. The in money in particular, but really the whole section comes from the what's known as the Truck Acts. It's not actually about trucks. Again, I just Googled funny truck, and this was the first image that came up, so you're all welcome. It's directed at a historical but persisting practice of attempting to pay employees in food. That's what truck means. It's matters either produced by the company or grown in company housing. You have the benefit of your own garden. 1,000 years ago, it's scrip, by which I mean company cash. Your BHP dollars you can spend at the company score, or rent of not necessarily houses, although that was historically a practice, often of machines. This began to be regulated in England in the Truck Act 1725. I do not have a copy of it, regrettably, but one day one will emerge. A series of amendments as the regulation persists and challenges to it arise. So sure, the first Truck Act, you can't pay people in food, it's got to be in the coin of the realm, you can't pay people in company money. And then you get to this situation where in around the 1800s, for example, you're seeing, the late 1800s, you're seeing, and the hosiery industry, which doesn't lend itself to payment in produce, payment in what the company produces necessarily, extortionate rent for equipment, extortionate charges. The reason it's considered a social ill is for a range of reasons, but it impedes labour mobility. You can't move job, you lose the ability to bargain for the true value of your labour if your value is tied, if your only remuneration is tied to paying at a particular place. It traps employees in a way. Prior to the Fair Work Act in Australia, it was largely governed by it was entirely, I should say, governed by state legislation. Weirdly variable across the various states as to what was permitted, what was not, whether there was a delineation between in full, in cash, and time. And the Fair Work Act, in its usual way, reflects a ugly compromise between the various provisions. There is a defence. Section 324 deals with deductions. As I said earlier, it's often described as unlawful deductions. What's actually happening here is there's an overarching obligation to pay in full, in money and on time, but there is an ability to defend against it. It's pretty limited. And it turns on authorisation by the employee, so it's a matter of choice. Bear in mind that we are talking about a statutory scheme that is fundamentally no fault. There's no intention baked within this. It's just that they are absolute obligations in terms of wages, in terms of the NES imposed by the Fair Work Act. 2 types of authorisation. 3 of them deal with various types of statutory instrument, either the Act or Enterprise Agreement awards, something that's been regulated that says you can do this. The more interesting one, and the one that's more complex, is subsection 1, subsection A, that it's authorised by the employee and principally for their benefit. Both of those, as a starting point, both of those matter. It has to be actually authorised. That part's simpler. Principally for the employee's benefit becomes clouded in some circumstances. You have, on the other hand, an employee who says, I would like you to send my payroll deducted union fees to my trade union. That is a classic example. Or whatever kind of garnishee orders happening. The voluntary entering into a garnishee order, I should say. To the more complicated training bond situation, which again, this is a heavily aviation-themed contravention talk. You are receiving a benefit in the sense that you are learning to be a pilot, for example, but is it principally for your benefit, and that scales down as the skill level drops? Is it truly in the employee's benefit to learn how to drive a particular kind of... These examples are always highly suspicious. Rail freight train in the state of West Australia. You need 4 to 5 AQF competency points. There's a secondary qualification to that, which is at 1A. It cannot be directly or indirectly for the employer's benefit. There's no sharing here. Very limited consideration of this. Training bonds, there's a couple of decisions. They're almost all in aviation, bar one, and they're pretty mixed in terms of what they say. There is a current controversy about this section. There's always been a bit of a lingering confusion about it, including via a case I lost in 2017 in the Circuit Court and have refused to put on the slide because you'll never find it, and also it's of no consequence. They were paying the bloke in pizza, and he did get a bunch of money, but there's some argument about the about some of the incidental payment requirements. So there's been 2 recent decisions, and by recent I mean middle of last year, published in a way that it's apparent that the 2 judges were writing pretty much simultaneously across the country. So in one way it illustrates the artificiality of the entire legal system, that you can't necessarily assume that anyone knows what's going on. They were argued quite differently. Wilkinson and Wilson Security is a judgment of Justice Colvin. It's an argument, a highly technical argument about whether night shift was payable in certain circumstances for a FIFO worker. The conclusion was ultimately that it was, but what is honour found, notwithstanding that the man had not been paid it, obviously, because there was a dispute, what is honour found was that Section 323, subsection 1 is not activated where the payment is in dispute. Like, you're not intentionally... It's not what the judgment says, but it's what it distills to, and you're not intentionally underpaying someone. You're going, got a real contest, no contravention. Creates some difficulties. It's sort of Schrodinger's civil penalty offence, in the sense that the second a court determines it and you don't make payment, surely you now have, particularly when you consider the need to pay monthly. And by the time a court has considered things, even at the cracking pace the federal court customarily takes, at least some months will likely have passed. The counterpoint is Eurocar Parts and Canon. The citations on the screen. The highly pixelated text is, and cartoon is 2 judges fighting, and the text says, yeah, well, I sentence you to death, incidentally, which is basically what's happening. What Justice Halley finds is specifically that this section is not limited, although it has its source in, and obviously does, the Truck Acts. It is not limited to that, and creates an ability to enforce rights arising in any way. Things that are actually payable, you can bring them. That reasoning is connected to some of the classic contest about this section as to whether it's an amount payable to an employee, which is what the text requires. There's been sort of ancillary argument about whether, it's under contract, whether the Long Service Leave Act applies, and the consistent pattern has been, yes, if you owe the money, you have to pay them. That informs that decision-making. That issue doesn't appear to have arisen in Wilkinson. And similarly, the novelty defence of I didn't mean to do it didn't come up in Euro car parts, but they're currently directly at odds and sitting against each other. Sometimes this doesn't matter. There's often a number of different ways to enforce payment of money owed, for example, with, say, an award claim. Indeed, with Wilkinson, the option would be to either claim a contravention of Section 50, Section 45, depending on the nature of the industrial instrument. You say, well, the award said you had to pay me, and often that's the coward's way out. Certainly what I do while this controversy is arising until someone turns up with real good facts. But sometimes it's critical, and it is particularly critical with contract entitlements. There's a separate path to enforcing those through the Fair Work Act, safety net contractual entitlements, but it's highly limited and it doesn't allow for civil penalties. So that's where the contest is likely to be. It's related to why a lot of the earlier controversy has been about whether it's truly an amount payable under this section. So, for what it's worth, I think Euro car parts is right, given the nature of the section, the way it's structured. It's very difficult to read in full as in full brackets if I agree that it is payable. And similarly, you are talking about what's effectively a no-fault jurisdiction importing these concepts of intention into it. Feels an odd fit. That's dealt with elsewhere in terms of penalty, but the whole scheme of the Act is about people getting the money that they're owed. That's me done. We'll do questions at the end to the extent anyone has any. But thank you for listening.
Thanks, Leo, and good afternoon, everybody. My name is Matthew Minnuci. As Leo said, I'm a barrister here at Greenway with him. Funnily enough, it feels a bit like yin and yang, as Leo and I are mostly opposed to each other in our matters rather than on the same side. I don't think we've actually been on the same side in a matter or come anywhere near close to that.
Delegates were both respondents.
Slightly different, where I'm acting for employer associations and Leo is acting for the ACTU, so I don't know we're necessarily on the same side in that case either. But thank you very much for coming, and we appreciate the people that are here, and to those of you online, we appreciate you spending your Monday with us, at least in the background, or for those who have it muted while they're accumulating their CPD points in the lead up to the 31st of March. I completely understand why you're doing that, and there is no poor reflection from our perspective on that. On the last point, before I get into the wage theft provisions about 323, it further to Leo's discussion of the distinction between the two cases, it does seem that there is a sort of larger group of the federal court judges at first instance lining up on the side of Euro car parts. So there's Justice Jessup, Justice Halley, now had Justice O'Callaghan as well express similar views, and that does seem to leave Justice Colvin as a bit of an outlier in the construction task. Now, I get to do wage theft in great detail, which is exciting, but it is, in my view, and I've said this to my learned friend, it is one of the great union marketing slogans of our time. It has stuck, and it has stuck incredibly well, because I hate to disappoint you, there is no such thing as wage theft on any statute book anywhere in the country. And that is despite what now is regularly referred to in the papers and everywhere else. The only reference to wage theft occurs in the title of the part of the Secure Jobs Better Pay legislation that introduced these particular provisions. It's otherwise nowhere to be found. But the relevant offence that we are talking about is an offence of failing to pay certain amounts as required, and that's in Section 327 capital A of the Fair Work Act. Now, I hate to disappoint all the industrial lawyers online thinking that this is going to be a gravy train of criminal cases that are going to run for years and years and years. In my view, and it's certainly a view that's shared by my colleagues in Victoria, is that it's highly unlikely we're going to see much, if any, enforcement of these particular provisions at all. and that is because of the nature of the inquiry that this offence essentially requires and the relevant burden of proof that any prosecutor is going to have to meet in conducting a case in respect of these kinds of offences. So the relevant provision starts and it obliges that an employer is required to pay an amount to or on behalf of the benefit of an employee under this Act, an instrument or a transitional instrument. We then go on. The required amount is not covered by subsection 2, which applies to state police and other things, which is irrelevant for present purposes. 3, the employer engages in conduct. And 4, the conduct results in a failure to pay the required amount to, on behalf of, or for the benefit of the employee in full on or before the day when the required amount is paid, due for payment. Relatively straightforward as an obligation, one might think. There is absolute liability, so for those in the criminal context, there is no defence essentially if in the context of the first 2 elements of payment. So you have to pay it and you have to pay it in the right amount. But the fault element for 1C and D, which is the engaging in conduct and the conduct resulting in a failure to pay, that fault element is intention. So that is, we are talking about deliberate acts of an employer that result in this particular underpayment. So for the first element, dealing with element 1 of the offence, again, some of this concept of prosecution beyond reasonable doubt will be familiar to the safety lawyers and the other criminal lawyers who are here, but it doesn't always fit well for the industrial lawyers because we don't necessarily have to use it a lot in the context of the Fair Work Act, certainly. But must prove beyond reasonable doubt that an amount was required to be paid and it was required to be done by reference to an award or an EA, etc. For example, if there is a classification dispute between the prosecution and the defence about the particular rate of pay and that is reasonably held, there is no offence because you cannot establish beyond reasonable doubt that this particular amount was required to be paid. Well, that's the argument, because if there is a reasonable hypothesis consistent with innocence, the element fails. And Colin can pull me up on any of my criminal law refresher context, given we have our resident safety market leader here with us in the room. So the importance about the absolute liability is that a mistake of fact is not a defence here. You're either required to pay it or you're not. We then get to the second element, engaging in conduct. So that is to do an act or omit to perform an act, and includes a course of conduct. Again, that's that concept familiar to the industrial laws and the scope of penalty. And then we get to element 3. So the conduct results in a failure to pay the required amount, and again, it is intention that is the relevant element here, which is where the rubber hits the road in these kinds of cases, or will hit the road. So one has to, and I should say too, that these prosecutions and the physical and fault elements, or the old actus reus and mens rea in the criminal context, are regulated by the Commonwealth Criminal Code. And they, if you read some of the criminal law literature, have overcomplicated what were quite well understood concepts in respect of actus reus and mens rea to physical and fault elements, and they create their own body of law about how all that works. But relevantly in this context, you have to intend the conduct would result in an underpayment, or you'd have to intend particular conduct but you're aware it would be the result of the conduct in the ordinary, but would occur in the ordinary course of events. So again, according to the explanatory memorandum, the accidental, inadvertent or genuine mistake underpayments are not caught by the operation of this particular provision. And what is interesting in the context of these offences, if you trust the explanatory memorandum, is that recklessness is not enough. So that if you're reckless as to the conduct, then it doesn't matter because it's purely directed at positive intention in terms of a statutory intent. I've put there the definition of recklessness in the context of the criminal code, and you can have a read of that for those watching on the slides if they need to, but it's not necessarily what the section says. So the section doesn't positively exclude recklessness as an intention, and that is certainly something that is going to be open to debate if it's ever prosecuted. So this question of intent, when one talks about the fault elements in respect of the conduct, there is a real question as to what the intent is related to or directed to. So is it just the conduct? That is, are you intending the conduct that results in the underpayment? Or do you have to intend the result? Do you have to know that it's going to result in an underpayment and intend to do that? Or is it you just intend to pay a particular amount regardless of whether it results in an underpayment or not? These are going to be interesting questions of construction and will definitely be part of any fight that will be faced in the first prosecution that comes about under this section, if it ever comes. And we'll come to why I am a little sceptical as to whether it will in fact come in a minute. And forgive me for being so cynical. This question of whether what the intent does and where it sits and how far it goes has been explored in some cases. I've just put some example cases, and I'm very grateful to my colleagues in Melbourne who have done a recent presentation, in particular His Honour Judge Palmer of the County Court, who was previously one of the preeminent safety silks in the country, has looked at this in some detail and referenced these particular cases that deal with this concept of intention in the criminal code by reference to drug offences and other types of offending. And there are some observations from the judges about those particular statutory schemes and how they interact with the fault element in the criminal code. They're dealt with in the cases, and if you would like to read them, please do. So we then look at whose conduct and state of mind is relevant in the context of this kind of offending. And the usual 793 Fair Work Act attribution of a body corporate provision doesn't apply here. What it does do is it shifts the requirement to those that are contained in the Commonwealth Criminal Code about how corporate criminal responsibility occurs. And that is essentially a summary of what it does. It attributes conduct to state of mind of employees, agents and officers of a body corporate to the body corporate. And for physical elements, the conduct must be within the actual or apparent scope of the person's employment or authority. So if they are acting in what would be relevantly the ordinary course of business, they're doing their job and they're doing correctly and they're doing it within what's expected, then the conduct can be attributed to their employer. For the fault element, it's talking about express or implied authorization for the particular conduct. And there is a question about whether corporate culture internally can deal with or attribute this relevant fault aspect. Now, corporate culture is not defined in any way as to what that means, but I'm assuming what it's intended to be directed towards is essentially if there is an organisation where the prosecution could establish, for example, it has a history of underpaying, a history of carelessness, a history of disregarding workers' rights, then maybe that can be used as part of establishing a corporate culture. I think there'd be some significant evidentiary issues about that in terms of tendency evidence, coincidence evidence and the like, about what kind of evidence of that would actually be admissible in the context of a criminal trial. But that is what the current state of affairs is in respect to the statute. There is a due diligence carve-out in respect of the fault elements, and what I've done here is set out a couple of cases that talk about due diligence in the body corporate space, not directly to employment, but essentially that one is trying to do or take reasonable care. So, for example, if you're a large corporate and you've got a payroll officer, you've got an HR officer, you've got a payroll scheme that is trying to ensure that people are paid correctly, you're doing all of that as a corporate employer and yet you still underpay, they're not going to be able to establish the fault elements because you're taking due diligence. Now, it might be that there's a debate in the context of a criminal case, and I'm looking at Colin, and the reason why is that there might be a question similarly in the reasonable practicability type sense, equating it to OHS as to where that line could or couldn't be drawn for the purposes of establishing that particular element. Related offence provisions are in the criminal code rather than section 550. And again, it's the classic criminal provisions of aiding, abetting, counselling or procuring. And then we get to penalties. So the penalty provisions for an individual contemplate a term of imprisonment as a maximum penalty or a fine, and a body corporate is a fine. What's important about the individual aspect is that there will be a question, obviously, at the body corporate level of the primary contravener won't be an individual, but maybe there's an accessory type prosecution as to which could land an individual, a director or some kind, in some difficulty. I've not given that too much thought, but it would seem that that is something that might be open on the provisions. Maximum fine is set out here. If the court can determine the underpayment, the fine is the greater of 3 times the underpayment, and whichever of the following applies. I've done the calculations for you because I had a moment going, I'm not adding that up. So the max penalties are 1.65 million for an individual and 8.25 million for a body corporate. Now, to make sure this works. This is where I come to what I think really is the nub of this. The history of these provisions are, again, like most things in industrial law, long and complicated and sometimes interesting and sometimes very uninteresting. But these provisions arose following a commitment in 2018 by the Victorian Labor government to introduce the first scheme in respect of wage theft. I was in Victoria at the time practicing in the area, and I wrote a paper at the time that said that it was unconstitutional, that is the state scheme. Lo and behold, I was right, and I take that because it doesn't happen very often, and the High Court, a challenge to the scheme proceeded to the High Court. At the 11th hour, the Victorian government repealed the provision so that the High Court were not able to rule on the constitutionality of the regime.
No, you're notionally right.
Sorry, notionally right. And the consequence of that meant that it was around about at the same time as that was occurring that these provisions in the Commonwealth regime were coming into play. But my question really, I suppose, and this is the difficulty, how are you going to prove the underpayment is intentional as a prosecutor? So unless there is an email that says, I hate Mr. Saunders because he is a union stooge and therefore I am deciding not to pay him his salary, it is highly unlikely that there is going to be direct evidence of intentionality of that kind. So what are you left with? You're left with a circumstantial criminal case trying to establish these relevant elements by the classic strands in a cable type analysis. And that can potentially, in my view, become quite difficult in an offence like this, where there are so many other moving parts where you could establish that mistake or other things actually resulted in the particular underpayment that we're talking about. The significance is that the case law says in the criminal context is that the prosecutor must exclude all reasonable hypotheses consistent with innocence in establishing or proving or prosecuting a circumstantial case. That, I think, will become a very difficult task, particularly if you're talking about some of these complicated pay provisions that we're all dealing with in awards and acts and everything else in terms of underpayments. There's then a question is it really worth it? And this is an interesting one. So what do you get differently in a civil context versus a criminal prosecution context? other than the conviction and the moral victory in the criminal space, in my view, there is a real chance that you are more likely to get a bigger whack in the civil penalty space, because the civil penalty space, or at least there's a real argument about it, isn't required to sentence by reference to classic sentencing principles. So if you look at Pattinson, you look at the state of affairs about that, you could now... Leo and I have had discussions about Pattinson, and there seems to be some certain agitation. I think Tim Game SC has written a rather compelling chapter in a recent book that suggests that Pattinson may not be as correct as the High Court says, and that it may have been fueled by the hatred that everybody has for the construction union, but we'll put that to one side for the moment.
Everyone on the court.
That's what Sorry, I was talking about the High Court. And that's, for all the levity aside, that is the Pattinson decision, I think, puts a significant handbrake on or arguably puts a significant handbrake on the calculation of penalties as compared to the criminal space. So if you're a first offender in a criminal case, you're more likely to get a significantly reduced penalty, have taken into account all those relevant principles of totality, proportionality, and all those classic sentencing principles. That doesn't necessarily apply in the context of civil penalty provisions, despite acting for employers and our best attempts to try and, all unions, bring those principles back in through other ways. That is something to consider, and that's particularly so given that the burden to establish a criminal conviction is so significantly greater than trying to prosecute it in a civil jurisdiction that is well known in the federal court and the federal circuit court. The penalty principles are well known. They can be dealt with by unions or by individuals or employers, as opposed to having to go through the prosecuting agencies to actually have the jurisdiction to bring the charge. That is a real question, I think, that is open. And these are some of the other practical matters about how one goes about dealing with these cases. And again, why is it worth it or why is it not? It feeds into that, but it was also relevant matters for us as practitioners to remember, because we don't always deal with criminal law or the criminal law and the conduct of a criminal case in the industrial context. So what is unusual for industrial practitioners, particularly respondents and mostly employers, I would say, is that you don't have to report anything to any particular agency. So the practice has been that one self-reports to the Fair Work Ombudsman. It tries to enter into an arrangement to reduce the penalty or to have an enforceable undertaking and all of those kinds of things. Now, there are provisions here that talk about incentives to self-report, and they provide some, but there's no restriction in the regime from the FWO, even if you self-report and even if you enter into an arrangement, referring that matter off to the Commonwealth DPP for prosecution or consideration of prosecution. So whilst there is usually some kind of disclosure to the Ombudsman, there is, I think, a real question now about what, if any, self-reporting is done. You'll be invited, I would anticipate, by the Ombudsman or the prosecuting body. Now, remembering the Ombudsman will probably take carriage of the investigation stage of things to do a record of interview. I've never advised a client to go and do a record of interview in a regulatory context in my life. Colin's shaking his head doing the same thing. I think Leo Saunders is doing the same thing. So one doesn't have to do any of that, and there's no compulsion to do any of that, particularly in the context of criminal law and the prosecution's burden about these things. Remembering in prosecutions, it's not an information exchange like the civil penalty type cases. You don't have to give them anything unless you are compelled by statute to do so, and they have to give you everything they've got. There's questions of criminal procedure about which there are many and there is questions of jurisdiction as to where they're going to be prosecuted. I mean, the idea is in theory, one could prosecute these cases before a jury in the federal court, which would be a whole lot of fun, but very interesting. What is also important to note is because they're Commonwealth offences, they can't be done by trial by judge alone. The Constitution says that they have to be done before a jury. So that also is an interesting feature of the Commonwealth regime. And then there's questions about how one takes instructions as a practical question. When you're dealing with the criminal law and you're dealing with particular matters, given your obligations as practitioners and obligations as counsel, there might be questions or you don't want the answer to, because it constrains the way in which you then are able to or are required to conduct yourself when you are defending the case. And so one has to think about that when certain things come up, and it might be that there are certain circumstances where you're telling your client, yes, thank you, I realise you want to tell me all of this, but please stop. Because, as I said, there are certain things that one might not want to know. But these are all really interesting things, but as I said to you, I will be very surprised if I ever see the Commonwealth DPP bringing one of these prosecutions ever. And if they do, I will be very interested as to how it goes. Now we're at questions for Leo or for me from anybody in the room. I'm not sure how the online people will do that, but I'm assuming some of you may know us so you can text us, or otherwise we're happy to do whatever that might be.
Yeah, all right. Yeah, I think in theory people can ask questions online, but my ability to navigate that is nil, so
Yeah, I won't
into the
be doing
void. Anyone in the room got something? Yeah?
More curiosity question about the last slide. Two questions. What does ROI stand for? And then the second one is that if there was going to be a criminal prosecution, do you foresee as barristers where you would need a criminal lawyer and an employment lawyer together?
So ROI is short for record of interview, my apologies. So that's where the regulatory body will ask you to come in and ask you questions, put certain facts to you and see what your response is. So for example, in the classic criminal context, you see it where there's the police station footage of the accused being grilled with the cops over the table and all of that. That's the record of interview stage. But if you're a regulatory body or a union or whoever you might be, you would not go anywhere. You'd say thank you very much for that invitation and politely decline, because it can be used against you. In terms of barristers as to who's going to be used, I would absolutely agree that it's highly likely that you're going to get a tag team or a group of individuals where you have employment experience as well as criminal prosecution experience. The safety practitioners are perfectly placed to do that work because they do the combination of that quite regularly. And the real important part will be the criminal procedure aspect of it. That is, the navigating through the courts and up to the trial stage, things like voir dires, which are the pre-trial evidentiary questions or other inquiries or admissibility of evidence, how to conduct yourself in front of a jury. All of these things are particularly referable to those people who do that all the time, and criminal practitioners are very highly skilled in that area.
And let's be realistic here. It's the same Evidence Act, but it hits differently in the two jurisdictions. So you do want someone who deals with that aspect. You'd have to have someone with a criminal background of some kind.
I've run 2 jury trials. I've won 2 jury trials, and I will not be doing any more. I'm keeping my clean record.
I've always wanted to do one.
It's fantastic fun. You'd have a great time.
I thought defo was my only way in. Anyway.
On the question of self-incrimination, is there a carve-out for corporates? Traditionally, corporates can't.
No, so it's this. They can't claim. There's no express carve-out, but essentially it's the same as the common law, as I understand it, or in the Fair Work Ombudsman context, where the regulator's pursuing documents. There's no protection for the corporate.
All right, that might be.
That's fantastic.
That's the end of that. Everyone can go home fractionally earlier. Thank you all very much for coming.
We really appreciate it.
Thank you.